and I included a lot of the quote because it's such a great quote. In lawsuit funding be less off, there was a law firm that had obtained litigation finance in exchange for a portion of the contingent legal fees that it was expected to receive from the settlement or adjudication of 5 matters. So this is a small portfolio law firm funding scenario, and you now know exactly what I mean by that, which is so cool when that happens. The court, citing PNC Bank v. Delaware Berg, said, look, litigation finance is not fee splitting, and this is why. Because a law firm is a business, and although it's one that has public trust, an issue of ethics, and duty of loyalty, there is no valid reason why a law firm should be treated differently than an accounting firm or a construction firm. It is a company, it is a business. And the rules of professional conduct ensure that attorneys who zealously represent the interests of their clients, regardless of whether the fees the attorney generates from the contract through representation remain the firm or must be used to satisfy security interests. They're not going to work any less because they have to turn over a portion of it to the person, the entity that was funding them. And then the court goes on to say, parenthetically, the court will note that there is no suggestion that it isn't appropriate for a lender to have a security interest in an attorney's accounts receivable, which is what I was referring to before. Banks do this, right? And so there is no real ethical difference, according to the court, whether the security interest is in contract rights, fees not yet earned, or accounts receivable, fees earned. Insofar as the professional rule conduct 5.4, the rule prohibiting the sharing of legal fees with a non-lawyer is concerned. And I thought that was really great language that really just kind of crystallized why with the issue.